Okay.
So let's focus our attention first on the child support, where the state is moving for child support to be calculated based on the parents' incomes and child support to be ordered. So I'll first hear from Ms. Looney and then hear from Mr. Daly and Ms. Nielsen.
Yes, the state is requesting a temporary child support order because the child began receiving TANF in January. We did use Mr. Daly's income from 2023 for all 4 quarters to come up with a net monthly income of $43.82 for him. And because Ms. Nielsen is currently receiving TANF, we did impute her wages at minimum wage 32 hours a week. We came up with a transfer payment of $733 from Mr. Daly to Ms. Nielsen that we are requesting begin in January of 2024.
And your proposed start date, again, you said was January?
Yes, Your Honor. We also received no written response or communication from either parent stating that they objected to our order.
Okay, thank you, Ms. Looney. Mr. Daly, did you receive the proposed motion or the motion and the proposed orders and documents from Ms. Looney?
No, I have not. The only documents I received was on the first from Shreya.
So you said you did not receive it, and then you said the only papers you received, and what was the last part?
On the 1st of April.
Okay.
And
So-
then my email.
Okay, let me just take a look. I'm looking in, okay, it looks like on May 19th, pardon me, March 19th, 2024, an assistant of Ms. Looney mailed those documents to your address on Avenue. Are you still on 9th Avenue, Mr. Daly?
Yes.
Okay. And then Ms. Nielsen, did you receive copies of those documents from Ms. Looney?
Yes, Your Honor, I did.
Okay. Mhm. So, Mr. Daly, the documents that were sent to you were a notice of appearance from Ms. Looney announcing that she's part of the case, a response to the petition in the case, sealed financial source documents, a proposed child support order, and also worksheets, a motion for temporary family law order, and a notice of hearing. And that notice of hearing set today at 9 o'clock as the time and place for that. So, Mr. Daly, did any of those documents that I mentioned, do any of those ring a bell, or have you seen any of those?
Yeah, I believe like I remember seeing how much we make and where we work at, the history.
Right. Okay. All right. So it sounds like you did get those documents that Miss Looney's assistant sent out to you. Did you file anything in response, Mr. Daly?
No, I have not, Your Honor.
Okay. Let me touch base with Miss Nielsen. Miss Nielsen, did you file anything in response to the state's proposed orders?
No, Your Honor.
Okay. So maybe I'll just go in reverse order. Ms. Nielsen, do you have any objection to the state's request related to child support?
No, Your Honor, I don't. I will say, though, I haven't received any child support since back in March when we separated.
Mine doesn't taste like they put the gold in.
No, my son apple.
So just a friendly reminder to all that are on the Zoom call, make sure that your phone is muted or your tablet or your computer. Look for the icon, looks like a microphone. You can press that, that'll mute and unmute. And then if you're dialing in using a phone number, you can press *6, that will mute, and then *6 will unmute. Thanks. Sorry for the interruption. Mr. Daly, what's your position related to the state's figures as far as monthly income and the proposed child support payment? Mr. Daly?
Yes. Yeah, 733 is what was wrote down what I'd have to pay, and I have rent, my own bills, and the cost of living, and I was wanting to consult my attorney about this matter and touch bases back.
Do you, as far as your net income, does that look about right? The state put down 4,300 net per month.
Yes, Your Honor.
Okay. And then they put down for Ms. Nielsen an imputed amount of 2,035, which is full-time minimum wage. Do you have any concerns with that figure?
No, Your Honor.
Mr. Daly?
No, I do not. But my checks vary month to month, and some checks are better than other checks, and some months are not so great for work.
Right. Right. And let me double check with Ms. Looney. Ms. Looney, you used, was it the employment security data information that you used to come up with that figure?
Yes, Your Honor, we take all 4 quarters and then we find the average income per month based on the yearly income.
So it's you basically you're analyzing 12 months. Is that where your figures come from, the employment security data?
Yes, Your Honor.
Okay. So I think so, Mr. Daly, like you said, you know, your income varies. And so what Ms. Looney used numbers from the Employment Security Department's database that takes into account the prior years and then averages it out to, or prior year, pardon me, and averages out to a monthly support amount. And that's where she came up with that 4382. So, so at this point, it sounds like both parties have received notice of what the state's proposal is. Both parties indicate that they're comfortable with the net incomes that Ms. Looney has proposed. And what happens with those net incomes, there's an online calculator that everybody uses to calculate support. So the net incomes are inputted into that, and it's a calculation, and it kicks out a number. So I recognize Mr. Daly indicated he wanted to talk to an attorney about this. He was given notice some time ago, and also, you know, the numbers aren't going to change. You know, as far as like once you input the numbers, it's going to kick out the same number. I mean, there may be quibbles on, you know, whether it's 4380 or whether it's 4400 or 4300 flat, but as far as the numbers that come out, they're not going to be dramatically different. So I'm going to grant the state's motion for the child support and have that start on January 1, 2024. And then those child support, I think those support payment, pardon me, the child support worksheets in order, Ms. Looney, those were, did you supply those to the court? I can't remember.
Yes, Your Honor. We did send those over on the 16th.
Okay, let me see. I have them here. Ms. Looney, I don't see them here. Let me look just one more time. I see some proposed orders that Ms. Nilsson had filed, but let me just look one more time just to be thorough. Okay, yeah, it looks like I don't have them, Ms. Looney. I apologize. Is that something that you could resubmit those documents?
Yes, Your Honor.
Okay. So, Mr. Daly, Ms. Nilsson, what will happen next? Ms. Looney will send the same copies of documents that she sent to you. She's going to resend those to me for my signature. I'll receive them, I'll sign them, and then they'll be filed with the clerk. So, any questions on the child support issue?
No, Your Honor.
Okay, Mr. Daly, do you have any questions?
No, Your Honor.
Okay. All right. That will take care of that portion of the motion. The next is related to Ms. Nilsson, your motion for a temporary parenting plan. And let me make sure, Mr. Daly, it looks like when we were here on the 27th of March, everybody agreed to serve each other via email. And so Ms. Nilsson filed a document where she indicates that she filed the proposed documents related to her motion for temporary parenting plan to you on April 1st via email. Did you get a copy of those?
Yes.
Okay. And so I wanted to just double check, Mr. Daly, there's Ms. Nilsson indicated some of her concerns and things that she wants to see in the parenting plan and things that she doesn't want to see in the parenting plan. And the indication that I got from you, the response that I got from you was that it looks like you had completed a substance use disorder evaluation on February 26th, and that there was no treatment recommended, and there was collateral contact with Ms. Nilsson in making that evaluation and that recommendation. Did you file any additional information related to the parenting plan?
No, Your Honor, I have not. I was trying to submit papers towards like the movement with the child, but it hasn't been submitted in the courts, I was told, yet, and I would have to pay to submit them. And so I didn't submit them because the clerk, Superior Court clerk, was telling me that it hasn't been submitted in the courts. But I'm trying to submit it though.
Did you say that you said you felt like you had to pay something to file?
Yeah, because it hasn't been submitted in the courts, I was told, and that you'd have to pay to submit them.
If the notice for relocation has not been filed, and he wants to file an objection to a before it's filed, there is a $56 fine.
Okay. I was under the impression that There was a notice of intended relocation filed, so that was filed on February 27th. So, Madam Clerk, if that was filed, then there would not be payment? Okay. So, Mr. Daly, as far as the relocation issue, the notice has already been filed by Ms. Nielsen. That means that there would be no payment required to respond to that. So you could file any documents or pleadings you'd want stating your position without paying anything.
Okay.
So that's the relocation, which we're not talking about at this point because it's premature because the 30 days has not yet elapsed from the time that you were served with a copy of that document. So we're focusing on the parenting plan, and there's a current plan in place basically where from back in November that you have supervised visits with the children or child on Wednesday from 5 to 7 p.m. and Saturday noon to 4 p.m. and they're supervised, and that you needed to get an SUD evaluation and a domestic violence evaluation. So are you in agreement with that continuing, or are you wanting something different? And if so, did you file anything to express that desire that you have?
I would like them to continue, but I've not submitted anything. I filled out the paperwork, but I was having trouble submitting them, so I haven't submitted anything yet.
Okay. So you said you're having trouble submitting them,
Yes.
such as?
What's that, Your Honor?
When you said you had trouble submitting them, what's the difficulty you're encountering?
Submitting them into the clerk. I had trouble, because I thought I figured I had to pay to submit them. And, but I have the paperwork filled out.
Okay. All right. Okay. Thank you.
And I was consulting my attorney, and I was had a meeting last week, but this week she's on vacation.
There's some things I want to do.
Okay. All right. Thank you. All right. So, Ms. Nielsen, you submitted a proposed parenting plan where you, just a moment, where you're indicating having 0 visitation or residential time for Mr. Daly. Is that accurate?
Yes, I would like to go for full custody.
Okay. And have Mr. Daly have 0 contact with the child?
Yes, Your Honor.
And that's based on the child being returned late, and that father not changing diapers, and concerns about inebriation or being drunk during visits.
Yes, Your Honor. There has been quite a few times where he has shown up under the influence to the visitation. The pictures that I have submitted with the documents, one shows where he is high, and then the other one also shows where he is high and has alcohol in his system. I feel that is not safe for my daughter to be around, hence the situation that we went through back in March of last year. I personally don't think that she should be around that, risking her safety.
Okay. Let me ask you a question. The visits are supervised, are they not?
Yes, they are. And I
And
have spoken with the supervisor about it on numerous occasions. And I told her how I felt about them, but unfortunately, she allowed them to continue.
okay. And then you if I understand correctly, you were not present during the visits, and you're looking solely at photos of Mr. Daly, and you can tell by those photos that he's high or drunk.
Yes, Your Honor.
Okay. Okay. Mr. Daly, anything else you want to comment on?
Yes, these are supervised visits, and I do not pick up my daughter for visitation or drop her off during visitation. So there's no way I could have dropped my daughter off late or picked her up late, and I've been accused of being drunk and high on visitation, which I have not been.
Okay. All right. So one of the things that I encounter on sometimes in the self-represented family law docket is that it's a very complex thing to do all this legal stuff and file papers and have a good clear idea how things are going to turn out, or how, what's important to be considered. What I do know is that there is a parenting plan that was entered in November of 2023. Ms. Nilsson has raised concerns related to diaper during the 2-hour visit. Diapers don't get changed on occasion. That the child these are her concerns. The child is returned late, sometimes up to an hour, and that Mr. Daly is either drunk or high at some of the visits, and he hadn't completed the SED evaluation, which we have proof that he has completed that. And we also know that the visits are supervised, and the supervisor has not ended the visits due to concerns for the safety of the child. So what I'm going to do at this point is I'm going to appoint a family law investigator. It's our family court investigator. Her name's Jen Schaefer. I just need more information. It's pretty scant information that I have. So I need more information. So she's going to do an investigation. She'll talk to each of you. She'll talk to other people that you mention and suggest. And she will submit a report for the court to review. She'll send copies of that same report to you all. We'll come back at a future time, which we'll set here in just a moment, to discuss whether it'd be appropriate to move forward with the restrictions that Ms. Nilsson is proposing, or if some other type of arrangement would best serve the best interest of the child. So I'm going to just do a quick notation. Bear with me one moment.
Your Honor, may I add something?
You may.
So he was supposed to do a domestic violence evaluation and a substance abuse evaluation. I received the phone call for the substance abuse evaluation after I had went and filed my paperwork. He has not done the domestic violence evaluation.
Right. I don't show any indication that it has been filed with the court. All right. So as far as the appointment of the family court investigator, I'll prepare an order and appoint her, Ms. Jennifer Schaefer, as the family court investigator. Information I have as far as phone numbers, Ms. Nilsson, your phone number ends in 9197.
Yes, Your Honor.
Okay. And Mr. Daly, I'm just checking for your information here, making sure. Let's see, previously Mr. Brungart represented you, and I just want to make sure that I have your updated information here in the case file. Drive address, Mr. Daly, is that where you're at?
Yes, Your Honor.
Okay, and then your phone number ends in 2433?
Yes, Your Honor.
Okay, great. So that's good. Then Ms. Schaefer can use that contact information to be in touch with you. Let's take a look at a date to return after she's completed her report. June 12th, we'll set the matter for June 12th at 9 o'clock in the morning for review of that family court investigator report, and then to take a look also related to the motion for the parenting plan modification. Are both parties, Mr. Daly, are you available on June 12th, Wednesday at 9 a.m.?
Yes, Your Honor.
Okay. Ms. Nilsson, how about you?
Yes, Your Honor, I am available.
Okay. All right, we'll see everybody then on June 12th at 9 a.m. Look forward to the communication from Ms. Jennifer Schaefer.
Your Honor.
Yes, sir.
Would I be able to continue my visitations?
Will you be able to continue your visitation?
Yeah.
I'm not making any adjustments to the current November 2023 order, so it continues to be Wednesday from 5 to 7 and Saturday noon to 4 supervised.
So they can continue starting on Friday, Saturday, I mean?
Yeah, there's been no alteration of that order, so if that should continue.
Okay, it has not continued for a while, and
Okay.
Paisley has not been able to come during visitations, and I just wanted to see if those would continue.
There's been no change to the court order, so if you feel that the order is not being followed or it's being violated, then your options would be to take court action. You could file a motion for contempt, alleging or contending that there's been a contempt, and we could have a hearing on that, or you can talk to the other parent and figure something out so there's compliance with that court order.
Okay, yes, Your Honor, and I have filed contempt charges also.
Your Honor, the reason why I stopped visitations was because of him.
So we're not going to discuss the issue at this point. If the court order is the court order, it's expected to be followed, and if any party feels that it's not, then they could bring a motion to address that issue. So we'll see everybody on June 12th in the courtroom.
Right,
As
thank
far
you,
as
Your
a
Honor.
motion to continue the case to a different date, or a motion to strike or just not have the matter heard. Anybody?
Hi, this is Megan Rhodes. I would like to petition for a continuance. I sent you a screenshot in the chat. My baby is super sick. She's been throwing up all morning. I had to go pick her up from daycare, and I think that I may end up having to take her to urgent care if that doesn't stop.
Ms. Megan Rhodes is on the line. I'll ask if Christopher Robinson, it's noted, and is on the line. Are you on the line? You're present? Oh, there you are. Okay. And I forgot, you don't go by Robinson. Say it again. Jensen, that's right. All right. And then Keith Lawrence, are you on the line?
Yes, I am, Your Honor. I may be able to short circuit this so we don't need to come back.
Okay.
We have a final review scheduled in June. I received voluntary hair follicle exams from Christopher and his girlfriend Tiffany. The allegations were that they drink alcohol, and so they both submitted the hair follicles with the alcohol test. Both came back negative. Chris has been doing very well in his supervised visits with Beth Fellows. Beth informed me that he comes prepared, is actively engaged with the child, and is doing very well, and the child's bonding with him. The only glitch that we ran into was I was informed that Megan had a new boyfriend, a gentleman by the name of John Pittman, who has criminal history. He's convicted of a child rape in the 3rd degree. And he had told Megan that he had appealed it and that the court had overturned that conviction, but the watch report does not support that. And Megan has since broken up with him. So that would be in a nutshell where we're at, Your Honor. Things are moving well, and I'm thinking that we can maybe avoid setting this over and just come back in June when my final report is to be done.
Thank you, Mr. Lawrence.
May I say something?
Mr. Jenkins, what do you think? Or Jensen, what do you think about that proposal?
Well, as long as I get a little bit of custody, I don't supervised visitation. I don't want to do that anymore. But I have more things I want to talk about. But if Megan has to go, couldn't we set over like for 2 weeks? But I want to not have supervised visits anymore. So we could do the like every other weekend thing, but I have other things that need to be addressed. And I could talk to Keith after this.
Okay, so you're giving kind of a nod to what Ms. Rhodes said about getting going and continuing the matter. And Mr. Lawrence, what do you think about that as far as just Ms. Rhodes need to get going?
That's fine, Your Honor.
Okay.
Oh, come on.
So we're looking at, there's a proposal.
Sorry, my baby's throwing up in my hand really quick. Can you just give me 1 second?
Sure. Yeah, sorry.
Sorry. Okay, just 1 moment, please.
Yeah.
Okay, I'm so sorry.
Zero worries. So would May 8th work? May 8th? May 8th is 2 weeks from today.
Yeah,
That's fine with me.
What's going to happen today, though? Like, do I still have to do the supervised visits?
Nothing would happen today. It would be just setting the matter over so we can talk a little bit more.
Well, I don't know. I just don't want to do the supervised visits anymore. It's really expensive. Keith has said that I'm doing well. So is there any way that I could get Nor for the weekends?
Ms. Rhodes, do you have any, based on Mr. Lawrence's input related to the negative alcohol test and good reports as far as the visitations, do you object to lifting the professional supervised visits requirement?
Request with it would be just that he would get her Thursday evenings and then drop her back off Monday mornings at daycare. And then if he's going to drop her off Mondays, it would be nice because I pack her lunch usually for the entire week on Mondays, if he could have her lunches for that week as well.
Okay, so Thursday, what time would be the exchange?
Whenever he gets off work, he could pick her up from daycare, and then on his way to work, he could drop her off.
Okay, so you're okay that it's not supervised and the visitation would be Thursday 5 p.m. until Monday at school?
Yeah, that would be fine with me.
Okay.
Because like I said, all I wanted was just to make sure that it was a safe living situation. So now that that has been established, it's like I've said so many times, I have no intention of keeping Nora from him. There's no way for me to verify that that's going to be a good place for her.
Okay. So let's go back just a little bit. Do we need to set it over 2 weeks?
Yes.
Even though we've talked about this issue? Okay.
There's other issues.
All right. All right. So what I'll do, Ms. Rhodes and Mr. Jensen, I'll draft an interim order allowing for the parent residential time to be Thursday, 5 p.m., Monday at school, for
Both
father's
weekends
time.
or just every other?
And I think it was it alternating?
Every other, it was alternating is what we had agreed to.
Well, we haven't agreed to anything, so
I mean, well, I would like to also spend time with her. So
You
it's,
get-
I mean,
you get it for the
I'm at
week.
work during the week. So it's not like I get that time with her.
Sure. So one thing that, if the parties agree to a particular parenting plan, I'll go with that. If
we're not
there-
going to agree.
If there's not agreement, then there's not agreement. And so we stay with the existing.
So every other.
Yeah, if the parties agree to alternate weekends, Thursday, 5 p.m., Monday at school, then I'll draft that order now
Okay.
and file it.
That's fine with me.
Okay. So then we'll come back on the 8th of May at 9 o'clock.
Okay.
Okay.
And then, so do I pick her up this Thursday then, tomorrow?
Ms. Rhodes?
That's fine with me, I guess.
Okay.
All right. We'll be back on May 8th for our additional review.
Thank you very
Okay.
much.
Thank you.
All right. Thanks.
Thank you,
Mr. Tatum is present in the courtroom. Good morning, Mr. Tatum. And if you could do me a favor, just make sure that microphone is fairly close to your mouth. That's great. Thank you. And is it Drema Tatum? Are you on the line?
Dreama.
Dreama, thank you. And so you are on the line, I guess.
Yes.
Okay, very good. All right, double checking here. Here on a couple of different items, Ms. Tatum had filed a motion for a temporary parenting plan, and also the state is making a motion for child support. And I'll double check to see if Ms. Looney, you're on the line, correct?
Yes, Your Honor.
Okay, great. So that's why we're here as far as what I know. So if there's a motion for a temporary parenting plan, there's a motion for child support. Is that your understanding, Mr. Tatum?
Yes.
Okay, and Ms. Tatum, is that your understanding?
Yes.
Okay, so let's start first with Ms. Looney, your motion related to child support, and then we'll hear from each of the parties.
Thank you, Your Honor. Yes, the state is requesting that a temporary child support order be put in place. The mother's petition is requesting that child support be addressed. She is a recent TANF recipient, so we have done an order. Mr. Tatum is receiving general assistance, which is not included as income, so we have him at $0 for net monthly income. And we have imputed Ms. Tatum as a recent TANF recipient at minimum wage 32 hours per week, which gives her a net monthly income of $2,035. The transfer payment for child support from Mr. Tatum to Ms. Tatum would be $50, and we would be requesting that begin in May of 2024.
Starting May 2024.
Yes, next month.
Next
No
month.
problem.
Great, thanks. Okay, thank you, Ms. Looney. We'll hear from Mr. Tatum.
I have been working, it's a private person. It's not, I've been putting apps, I'm signing up with every temp agency in town.
Mhm.
My vehicle just broke down, so I ended up selling it. Most of the work is out of town, and if I do go to work with my SVD, it's gonna have to be at night after my SVD classes. I've had a couple of offers, but like I said, I have to get a vehicle first. The person I work for doesn't pay that well, so I'm not making that much money right now. I did file for ADB, which is only $411, and on the 24th of next month, it turns out it goes to $960 a month for SSI. So I would just like visitation. I mean, I just like to see my son. I mean, haven't seen him since the day after Christmas. So
as far as the states, they're proposing that your income be set at zero and that you pay child support at $50 a month.
I'll pay them. I don't have a problem paying child support. I mean, you know what I mean?
Okay. And Ms. Tatum, what's your input related to the child support proposal from the state?
I'm fine with what they set it at.
Okay. All right. Well, we'll talk about the residential time here in just a second, but as far as the child support, I'll adopt those figures proposed by the state and order the $50 transfer payment from Mr. Tatum to Ms. Tatum to begin on May 1st of 2024. Then let's
Thank
move.
you, Your Honor.
Okay, great. And then as far as those orders, I don't think I saw proposed orders on that. Is that something you could present to the court for signature?
Yes, we sent them the same day, so something may have occurred on the 16th. The orders didn't make it to you, but we will send new copies, Your Honor.
Okay. Okay. And I'm going to double check one more time to make sure that I didn't inadvertently look over them. Have some proposed orders here from Ms. Tatum. Yeah, it looks like the 16th, something went awry on that date, so I apologize for that. And if you could help us with just resending those, that would be appreciated.
We will do that, Your Honor.
Okay, thank you. All right, and then now we'll turn our time to the motion, Ms. Tatum's motion related to parenting plan. I read the pleadings that both of the parties submitted. So I'll hear first from Ms. Tatum, then we'll hear from Mr. Tatum.
Your Honor, I would like no visitation at this time. I have a protection order with Robert Tatum, and that was to give time for him to do the things that he needed to get visitation and get a parenting plan in place while my dissolution of marriage went through. He has been violating that order. I am going to file a motion on that because the Kelso police have failed to pick up charges on it.
Do you have is it a civil protection order, and do you have a case number?
It is a domestic violence protection order, and yeah, I can get you a case number 4308.
All right, just give me just a moment to pull that up.
No problem.
Your Honor.
Hold on a second. Okay, thank you for letting me to review that. It's a January 29th, 2024 domestic violence no contact order that requires Mr. Tatum to stay away from Ms. Tatum and also not have zero contact with her, and that custody is granted to Gage, to Ms. Tatum. So that's the order that's there now. So Mr. Tatum, do you have any other information you want to share about?
Yeah, I do.
Sorry. Mr. Tatum, I apologize. I was going to let her finish, and then I'll turn the time to you. Sorry. So Ms. Tatum, any additional information you want to share?
Your Honor, yeah, I just would like it to stay until he follows through with the things that I outlined in the parenting plan and provides proof of mental health, drug and alcohol, and then also gain employment. He has a tendency to not work, and he bounces around, and I think he should be able to maintain employment so he can have steady living, so he can see his son.
Okay. And then I believe, so as far as the time, residential time for Mr. Tatum, your recommendation that he have no time with the child?
Correct.
Until what? Till when?
Until he gets a mental health evaluation and follows through with any recommendations of treatment, SUD, and completes it, and has, I would prefer 6 months sobriety. And then, yeah, he needs to follow through with the mental health, and then also have employment. He needs, or if he's going to be on Social Security, at least prove that he's doing that. He always lives
as far as employment, I was just going to chime in. As far as employment, the courts generally don't precondition a visitation with a parent whether or not they're employed or not. So just share that with you.
Okay, well, at least he needs to do the mental health and the drug and alcohol.
Is there, if there's some type of supervision for the visitations prior to the evaluations and treatment being completed? What do you think about that?
Well, my mom, if he wants to pay to have states or somebody supervise it, my mom is not willing to do it.
Okay. Okay. All right. Thank you, Ms. Tatum. Mr. Tatum, what's your view on
Okay, whatever Chase to my kid. Basically, the SUD is 9 months. I haven't seen my son since day after Christmas, so I think she's a little far stretched on the timeline. If I got to wait 9 months to see my son, I think it's ridiculous. I'll pay the money. I don't care what it costs.
Okay.
I'm going to treatment. I'm doing mental health, and I'm working. So.
And it sounds like in your paperwork that you submitted, Mr. Tatum, you're okay with Ms. Tatum being the primary custodial parent, but you want some visitation time with your child.
Yeah, you want visitation.
Okay.
I'm doing everything I need to do. If I have to, I'll cover custody. I'm not gonna play a game. It's retarded.
Okay. And as far as the 9 months of the SUD treatment is,
you cannot complete SUD till 9 months. You got to do it for 9 months.
okay. Where are you at in that process? Have you had the evaluation yet?
3 months.
Have you had the evaluation yet?
I've had the evaluations. I've done mental health. I'll get the compliance reports if she wants. I mean,
okay.
I just want to see my son. That's
how often are you going to group?
Yes.
How often are you going to group?
About 3 months. It's been 3 months now.
how often per week are you going to?
Yeah, I guess 9 hours a week, 3 days a week.
Okay, and which agency?
Core Health.
Okay.
I don't know what it costs. If you could let me know, then I'll find out. And I definitely like to get some supervised visitation going on.
Okay, and where are you?
Situation.
Have you had any? Have you had any mental health evaluation or treatment?
I've been going to mental health.
Okay, is that also
That's
at
all for
Core?
Core.
How frequent are you going?
What's up?
How frequent do you go?
It's every week and a half.
Okay, who are you meeting with?
Just depends on which one they give me.
So you don't have a regular counselor?
No.
Okay. Why don't you have
the other Core Health? 1L was my mental health counselor at the other Core, but they switched me to the other one, and I'm not really comfortable with the ones they've been giving me. I'd like to go back to the other Core, not the main one, but the other one, and keep my actual regular counselor.
Okay. Okay. And as far as information related to, your treatment, how often you're going, is that documentation that you can submit to the court and
Yes, I
provide a
can.
copy to Ms. Tatum?
Yes, I can.
Okay. And just to make sure I'm correct in reading your documents, you're okay with Ms. Tatum being the primary custodial parent, and I also read that, and this is what I want to confirm with you, is that you're comfortable with her having sole decision-making authority related to education and non-emergency healthcare.
I also like to know if he's in school. I mean, is he going to school? I have no idea. I mean, I don't know. I ain't since Christmas, so.
Yeah, any parent can check on their
Okay.
child and contact the school and
All
get
right.
information related to that. Okay. Okay, and so the last contact you said was in December.
Yeah.
Okay. All right.
And as far as violating the no contact order, they're the ones that served me, and Janet McKee is on the no contact list, so she's the one that served me. I don't understand why she's doing this. I just don't understand it.
Okay. Well, yeah, that order's in place. I just encourage everybody to be aware of the conditions and the requirements of that, and do your very best to abide by that. So here are the allegations from Ms. Tatum. She indicated that there's concerns related to SUD and mental health, and Mr. Tatum indicates that he has those evaluations and that he's engaged in the treatment. I need to see that. I need to see that information to verify that before I make any changes related to the parenting plan or residential contact. I just kind of trust and verify is kind of the idea. So I need to see that first before I can make any order related to parenting plan. So
I just drop those off the clerk's office then when I get them.
yeah, you can do that, and then you need to make sure that you send a copy to Ms. Tatum.
Okay.
And so she can see them. So what I'd like to do is continue this. How quickly do you think you can get those records?
I could have them by tomorrow.
Okay.
I got this $27 for the paperwork. I've already set the paperwork up. I did have my counselor call her to do the compliance reports, and she said it was a third party no contact, which was a violation. So I figured the best way to do it is have my counselor let her know, and then she got mad. So I'll get the paperwork and turn it in and do what I got to do.
Okay. So if looking at a 2-week set over, Madam Clerk, do you have an idea of where we sit with as far as numbers on May 8th?
16.
Okay.
7.
We're going to set it to May 15th.
Okay.
So we'll be back on May 15th. We'll have those documents that you've submitted. Ms. Tatum will have an opportunity to look at those. We'll come back and we'll make some decisions related to the residential time. So yeah. So Mr. Tatum, any questions about that?
No, also I'd like to know who do I contact about to have supervised visitation. If I get a visit before then, that'd be nice.
Yeah, there's one agency in town. Beth Fellows runs it. Last name is Fellowes Fellows.
Okay.
I'm not sure of others in town, but you could check maybe with the courthouse facilitator. The courthouse facilitator is an employee of the clerk's office. They may know.
All right.
And just kind of Google search too. Other than that, those would be your options. So let me check with Ms. Tatum. Ms. Tatum, are you available on the 15th of May?
Yes, I am, Your Honor.
Okay, let's plan on coming back on May 15th at 9 a.m. Mr. Tatum will submit those documents related to his mental health and also to the SUD. And then we'll take a look at those and we'll come back and you can argue your points and then I'll make a decision related to the residential time. Any
Okay,
questions?
and until then, it's still no visitation.
Yeah, at this point, I'm not ordering any visitation at this point.
All right, thank you, Your Honor.
Okay. All right, so we'll see everybody on the 15th.
Thank you.
All right, thanks. Ms. Fike is on the line.
I'm here.
Okay, welcome to you, Ms. Fike. And Joseph Sorensen, are you on the line?
Yes, Your Honor.
Okay, welcome to you, sir. All right, so we're here on Mr. Sorensen's motion for a clarification regarding vacation and other, sounds like holiday events. Wanted to make sure, I didn't see proof in the file of the service of the pleading upon Ms. Fike. First off, let me touch base with Mr. Sorensen. Did you submit a declaration or affidavit of service related to that?
I did file one more.
Okay.
She had filed and they never served me, so I just I looked it up on Odyssey.
Okay. Yeah, there it is. There it is. Yeah, I see it. I see it. Okay, great. Thank you. Thanks for confirming that and making mention of that. And then, Ms. Fike, did you receive a copy of those documents related to the motion for clarification?
Yes, I did.
Okay, I'll hear from you, Mr. Sorensen, then from Ms. Fike. Go ahead, Mr. Sorensen.
I'm here in hopes to establish and clarify the start and finish time for the spring break section of the holidays.
Okay.
As there is not one listed on the parenting plan. The weekend school was let out was Easter weekend. Was my year for Easter with our son, and my residential weekend as well. The school flyer and the district calendar stated spring break started on Monday, April 1st, the day after Easter. And since the parenting plan did not state a begin time, it made the most sense to follow the school district calendar, as it allowed both of us to have our scheduled holiday. That seemed the most fair and logical. To confirm that, I marked it on OFW on February 14th, which would have been 46 days in advance, with a detailed start and end time. I would get Easter weekend, and she would have him from April 1st to the 7th for spring break. Ms. Fike did not object, discuss, or voice any issue, but in fact, she validated it with our son, just as I did. However, per usual, Ms. Fike argued at the last minute that evening before she emailed me demanding our son to come home the next day, just disturbing our Easter weekend schedule. My objective here is to have fairness with all holidays for Ms. Fike and myself to enjoy our son and have to avoid conflict. I'm requesting that the spring break does not include the other parent's weekend, especially if it falls on the other parent's Easter. Next year, for example, spring break will be April 7th to 11th, which lands between Ms. Fike's weekends, leaving her schedule uninterrupted, and 5 days for me to have him with spring break, which Easter falls on April 20th next year, which is Ms. Fike's already scheduled time, and it doesn't include spring break.
Okay.
So I'm asking that that we adhere to the district calendar as far as spring break's concerned.
Okay, thank you, Mr. Sorensen. Ms. Fike?
Yes. Easter is not in our parenting plan for every other year. So, and I've only gotten Christopher on Easter 2 years in the last 6. We've never had an Easter together with our whole entire family here. Spring break. This is my first year having spring break. You just put it in our parenting plan in January, and this would be my first one. School got let out March 29th, that Friday, early release at 11:50 to begin spring break. So I figured, it's my year. I should have got him from the day school got out for that early release until school resumed. That's how I figured. Like, my husband's schedule is from Friday. He gets half of spring break. So from Friday to Wednesday, and then they go to their mom's Wednesday to Sunday. So we got my stepkids from Friday to Wednesday, but Christopher didn't even get to come here till Monday because he wouldn't let me have him Friday. So that's why we do need clarification, because I feel it should have started Monday early release to, like the email states, to begin spring break, but I didn't get him till that Monday. But regardless, we don't have Easter in our parenting plan every other year. Last year, I got him with just my stepdaughter. Our stepboys weren't even here. So we've never had 2 Easters in 6 years is not a lot, because it always landed on his dad's time. That's why I wanted spring break added as well, because that was in there. I feel like I should have got Christopher on that Friday. Yeah, the district calendar says Monday through Friday, because that's their district calendar, but everybody else is spring break starts on the last day of school, just like every break. It starts the last day of school before that break. That's how I see it. But I didn't get him till Monday instead of Friday after school. So we only got 2 days with all of our kids together for spring break, which is not a lot. So there definitely does need to be clarification.
Okay, thank you. All right, so it sounds like a genuine disagreement of what the court order is, and the court order, there is some vagary. It's not ironclad. You know, it reads spring break begins and ends. Then it says day and time. There's nothing put for day and time, and then it says odd years with Joseph Sorensen, even years with Ms. Fike. So understandable why the parties had differing views on this. The way I look at it, when it says spring break, a break is a break from school. Okay, that's why we have spring break. It's generally an educationally based break. And so when you have a break from school, that means you don't go to school. So then school runs Monday through Friday. And so if you have a break from school, the break is Monday through Friday, notwithstanding kind of the expectation of like, okay, it's Friday after school. We've got this nice long weekend, and then we've got all of next week off. So I can see why one might think, okay, the Friday, the weekend attaches to the spring break. But I think going forward, just with that rationale is that, you know, an educational break is based on the educational calendar. And so when you have a break, it runs Monday through Friday. So that's how that will be interpreted going forward. So use of the school district calendar for that purpose will be used going forward in determining when spring break is. So my interpretation is that it runs Monday through Friday. So I'll just draft up just a brief order, order of clarification that states that, and I'll file that in the court file so the parties can take a look at that. Any questions about the court's ruling?
If I may, Your Honor, is there there's a couple other that are pretty vague on, as Miss Fike has stated, that Easter is not in the parenting plan, and we have always alternated every other year, even an odd. As she stated, she had him last year, and this year was mine. Is there a way to put that in that as well, as far as Easter for even an odd?
Couple comments about that. One, Washington is a notice pleading state where if a party wants something, they have to give notice to the other side, and that notice is generally through documents and service of the same. In your motion, Mr. Sorensen, it seemed to be related to the spring break issue, controversy, if you will. And so if there's agreement between the parties, sure, I could include that in the order. If there's not agreement, then there would have to be a separate motion, which I guess I think that's kind of a waste of time, but yeah, that's
because we kind of
got the notice pleading and giving somebody an opportunity to know and respond.
Okay, because we kind of missed the court date after our final decision. We were supposed to have one more court date that you had told us to go look over the parenting plans, and we were going to discuss if there's any fine tuning that we needed done to it, and then that court date had gotten canceled. Is the only reason I asked.
Okay. So yeah, so if there's agreement related to that, then the parties could certainly agree. If there's not agreement, then there would need to be a particular motion brought forward to the court.
Okay.
All right. So at this point, I'll type up that order of clarification. Should have it done prior to Friday or on Friday, and then the parties can get a copy of it by checking on Odyssey or getting a copy from the clerk's office.
Okay. Thank you, Your Honor.
All right. Any questions, Ms. Fike?
Nope.
Okay, that'll conclude things. Thanks. I'll ask if it looks like Ms. Jablonski is present. She's coming forward. And is Mr. Lyon on the line?
Yes, I am.
Okay. All right. Welcome to both parties. We're here on a review of the restraint order. I was just handed just a few minutes before court a document related to, it was a law enforcement report that I think Ms. Jablonski must have handed that to the clerk to hand to me. Is that correct?
That's correct.
All right. And Mr. Lyon, have you seen that document?
No.
Okay. So part of the reason why we're here today is to review any CPS reports or any law enforcement reports. It looks like it was kind of a late breaking document. Mr. Lyon, you have not seen it. I can just give you a shorthand version of it. Basically, they indicate that they're not moving forward with criminal charges against a significant other of Ms. Jablonski. They're not filing charges. They felt that law enforcement felt that there's not probable cause. So you know, in all fairness to all parties, I mean, it's late breaking news. I skimmed over it pretty quickly. Mr. Lyon has not seen it. So I'm not sure if we continue it just a short period of time so everybody can look at it more clearly and then come back and then speak about it more, or if the parties have different suggestions. So Mr. Jablonski.
So I was given the report yesterday, actually. Detective Nastansky was trying to get it before the court hearing. So I went ahead and submitted this morning. I do have a copy that I'm going to be sending Carl as well.
Okay.
But with that report, you know, it states that the case is closed. There's no reason to withhold the children at this time anymore. So I'm asking that the kids come home.
Okay. Thank you. Mr. Lyon?
Yeah, so as far as I know, the case is still ongoing. I had heard from Officer Nisanti, Detective Nisanti, I should say, that they were still investigating it. As far as the legal end for Washington goes, as for the social aspect of from Oregon DHS, is that I know that Cassie Talbot, when she was here last time with me, said that she would get a report out to us as soon as possible, but she ended up going on an emergency leave, and she's been on emergency leave the whole last month. I did manage to finally speak to her supervisor, which is Amanda Hole, and Amanda Hole told me that they had sent out a letter to Christopher Vaughn that they find him guilty of sexual abuse towards my son. So I'm trying right now to get that report from them.
Okay.
But I just sent in the request for those records recently.
Okay, thanks for that update. Mr. Blonsky, do you have any information regarding CPS?
Yes, I do actually.
Okay.
So I had visitation over the weekend on Saturday. I want to say it was the 19th, I believe, or the 20th. And during that visitation, my son came forward and gave a whole speech about everything. I turned that evidence into Detective Nistansky. Detective Nistansky then finished her report. She talked with the therapist that Carl has been seeing over on the Oregon side. I spoke with Detective Morris and Nistansky, and they both have no probable cause to find this case.
Right. We talked about that earlier as far as their determination. As far as the CPS, any information from them, Mr. Lyons indicating that they're set to issue a founded.
I did not receive that letter.
Okay. And Mr. Lyon, you have not also received that letter, correct?
No, that I wouldn't receive that letter because I'm not the party. I'm not the party like getting the the notification, but I'm requesting it from their records.
Okay. And so did they indicate that they actually sent it, or they were planning to send it?
They had indicated that they had sent it out on the 10th and that Christopher had received it on the 15th.
Okay. Any knowledge of that, Mr. Jablonski?
No, they were told in the last, Cassie Talbot said in the last court hearing that she was going to mail it out at the end of the week. We waited and waited and waited for that letter, but nothing ever came.
Yeah, last time we was here, she said it's ready to go. I'm going to send it.
Yeah, and now he's saying that she mailed it out on April 10th. It's still not here.
Okay. All right. Well, first off, just with the late breaking report that Mr. Lyon has not seen, he's heard just a brief summary of it. Ms. Jablonski's addressed it a little bit. He needs to have an opportunity to look at that in fairness to all parties. And then Ms. Jablonski, you said that you would be getting that to him, or you have already sent it to him?
No, I just submitted it today, so I will be getting him a copy.
Okay. So Mr. Lyon, you'll have an opportunity to see that. And then as far as the CPS letter, it sounds like they've sent that according to the information from Mr. Lyon. So we need to see a copy of that letter too. And so they may be not necessarily contradictory, but contraindicated in that the one finds no probable cause for criminal charges, the other makes a finding of founded of a particular act. So I guess you can have both things, but we need to see that. We're still kind of in that waiting game. We're getting closer. We've got the police information, and we need to get a little bit more from the CPS folks. Mr. Lyon, did you submit a public records request to get a copy of that document from CPS?
Yes.
Okay. Did they send you back what they call a 5-day letter that says they give an estimate of the time frame that'll take to research and send that letter to you?
I just sent it out yesterday because that's when I managed to talk to Amanda Hole. So as far as my knowledge, I haven't gotten a 5-day letter yet.
Okay. All right. Oh, if you submitted it yesterday, yeah, you wouldn't get it yet. So I think if you know, the more people that are seeking or trying to get that information, that there's a greater likelihood that we'll get that information. So Ms. Jablonski, if you're in a position to make a request to get that same letter, I would encourage you to do so. That will help clarify things as far as the motion and making a determination. So I'm not going to make any determinations today. We still need to get that information from CPS, and Mr. Lyon needs an opportunity to look at the law enforcement report. We're at the 24th today. We're not available next week. The 8th is pretty full, so the next available time would be on May 15th. So that's what I'm proposing for the next day to review those documents.
Okay, Judge, I have a question beforehand.
Sure.
With visitation, I would still like to continue my visitation with the children. I'm not the one being accused. So I ask that this time I was going to Pendleton. It was rotating off and on between Pendleton and Halfway, which would be Hood River. When I was going to Pendleton, I was having to get up at 5 a.m. and not getting home until 11 p.m. at night on Saturdays. I don't feel as if that's fair. Our parenting plan is in Washington State. So I'm asking that we can agree to meet halfway.
So you're talking about the March 22nd order that was issued last time?
Yeah.
Okay, so you're asking to modify that. So as a general rule, as you probably heard me explain, that if somebody wants to modify a court order or ask the court to order something, then notice needs to be given to the other side. And if they agree to it, great. If notice hasn't been given to the other side, then we generally don't entertain those, because the other person doesn't know what you're asking, hasn't had an opportunity to prepare, and you don't have an opportunity to respond to their reply. So that's kind of where we're at. Is that?
Okay, so the visitations will still continue with Pendleton and Halfway until the next court hearing.
Yes.
Okay.
Yeah, unless there's agreement with Mr. Lyon. I mean, that order is kind of the baseline, right? If any party can agree, two parties can agree to deviate from that if needs be, if it's in the best interest of the child, or if the parties think that's okay, people can to make changes. But if there's not agreement, then the order controls.
Okay.
All right.
And then I also got some news that DCYF is no longer on the case. They handed it over to a company that oversees the cases due to it being open for too long. That's what I was told. So it's like Region 6 units or something like that.
Okay. Yeah, as much information that could be gathered and presented on May 15th would be helpful to have a full picture. All right. Mr. Lyon, do you have any questions?
It sounds like we're just continuing the order till May 15th. So I think I'm understanding of that.
Correct. So I believe I'll be entering an extension of the immediate restraining order that was originally issued. I'm just tapping notes here on February 12th. So I'll create that order, extending it to the next date of May 15th. And then we'll reconvene at that time. Any questions?
Yes. So this weekend's visit, that'll be the halfway mark because I was in Pendleton last Saturday, correct?
I don't know. It says on the 1st, 3rd, and 5th weekends, respondents shall have 8 hours supervised visitation with the kids in Pendleton.
Okay.
So, Mr. Lyon, what's your thought on that?
I mean, yeah, I'll go with the order. I'm perfectly fine with it.
Okay. Yeah. I'll just encourage the parties to follow the order. Okay. We'll see everybody on May 15th.
Okay, thank you.
All right.
Is
Sounds
Desiree
good. Thank you,
Comba
Judge.
on the line? Desiree Comba, if you're in the courtroom, come up to the front and take a seat. If you're on the court call or on the Zoom call, if you could unmute and state your name. Okay. No response from Ms. Comba. Ruben Comba, are you on the line?
Yes, Your Honor, I'm here.
Okay. Welcome to you, sir. So you're here today on your motion for contempt related to not seeing your child and concern that your child has left the state with the mother, correct?
Yes.
Okay. So one thing I wanted to double check, there was an order to show cause. You asked for a motion to cause Ms. Comba to come to court and show cause why she should not be held in contempt. And you mailed that certified receipt on April 10th to her address in 4th Avenue in Kelso, the last known address. There was an order allowing service by mail entered on February 21st of 2024. And it allowed for service, it specifically allowed for service of a summons and petition to be served by mail. And so the mail that was sent on April 10th, have you received the certified return of that?
I believe so. I thought I submitted it to the court.
Just confirming with you. So Sabrina Clements assisted you with that. And then I show there's a receipt, certified mail receipt with tracking. And did they give you a kind of, what was the outcome of that? What was the outcome of that? Did they serve it? Did they, because sometimes they'll give a statement of like on, such and such a date, we delivered it to the home.
Well, we send it certified, and then we send another one uncertified. The one that is certified gets sent to the home where she has lived, and then the other one that was being forwarded to where she's currently living, somewhere in, I think, Tucson, Arizona.
Did you submit that second one, the Arizona one? Did you submit an affidavit of mailing?
I don't believe, actually, a few, I think I did. I'm pretty sure I've submitted the receipts in all of them.
Okay. So
This
I'm
has
just
been
looking,
a long
I'm just looking
process.
through what I'm seeing is, let me see if this other document has the Arizona address on it. Yeah, what I'm seeing is I see the certified mailing on April 16th. Well, that's when it was filed and is mailed on April 10th. But I don't see the Arizona address on there, and I don't see a separate document showing mailing to the Arizona address. So, okay, so that's kind of where we're at with that. So at this point, do you have, go ahead.
Sorry.
Go ahead.
I'd like for her to be found with the parental interference, and then for me to contact authorities, because that's the way that LVPD said that we'd be able to go about this.
Okay. So one question I had, Mr. Kamba, when the documents were sent certified mail, do we have a report from the post office stating that they mailed, or they took those documents to the address and mailed them and delivered them?
Yes, I believe they were sent to a PO box in Tucson, Arizona, and I do have the address saved somewhere on where the where they were sent to. The receiving address, the receiving paperwork was signed by an employee that works in Tucson, Arizona, and I called like 40 different of the where they received the mail to find where exactly it was delivered. Because I looked up the employee's name, and then it said that he was an employee at can't remember what the business is called that receives mail. I'm sorry. And there's a PO box there for her.
Okay. Okay. So the one document I have in the court file, it relates to the certified mail that was mailed to the Kelso address for Ms. Kamba. There's a tracking number on there. There's a certified mail tracking number, return receipt tracking number. What I know is that it was dropped off, and they estimated that it'd be delivered on April 12th. I don't have anything from the post office that says they actually delivered it. So that's where those tracking numbers come into play. There's tracking numbers that you can track that. There's the web address. And so what I know is that it was mailed, but the certified return receipt, it's unverified that they actually delivered it. Do you understand what I'm saying? Is it the loop hasn't been completed? The loop was started, it's come around, but it hasn't been completed because I don't know if the post office actually got the document to that address.
Okay.
And the document that you filed on April 16th has a tracking number on it, two different tracking numbers where you can use that number, put it into the website, and then they'll let you know if it was delivered or not.
Okay, so what is it that we can do today if it wasn't, what is it that I have to do in order for us to move on in the court because she's not going to respond anyways.
Right. Right. So it seems maybe hyper technical to say that, you know, the post office hasn't filed something that says they actually delivered it via the certified return receipt. So that needs to happen. I need to see some type of documentation from the post office that they in fact delivered that to the address in Kelso, which is accessible through their website with the tracking numbers that you had submitted in the case file.
Okay, so I'd have to look it up and then submit whatever documents I find for the court.
Right. Right.
Would we be able to move this to next week?
I would like to move it to next week. However, next week is what we call judicial conference, where the majority of the judges are out at a conference for the week, and so we don't have a docket that next week, which is on the 1st. So the next available time, and I would be happy to set it on the 8th. It's kind of over full at this point, but I know that there's some timeliness concerns in this case, and so we can set it to May 8th. So if you can get that information submitted as quickly as possible, we'd be ready to review things on May 8th.
Okay, yeah, because it's almost his birthday, and you know I've missed 4 of his birthdays. If I miss this birthday as well, and you know I haven't seen him in like 8 months, so yeah.
Okay.
Thank you so much.
So we'll be back on May 8th at 9 a.m.
All right, thank you, Your Honor.
Okay.
Yes,
Thank you,
Your
Mr.
Honor.
Gamba. Okay, welcome to you. Brandon Lovato, are you on the line? All right, Brandon Lovato, are you on the line? All right, Mr. Lovato, I'm not able to hear you, so Ms. Hastings, do you mind doing me a favor and just muting for a bit, please?
Yeah.
Thanks. So Brandon Lovato, if you're on the line, please unmute and state your name. Brandon Lovato. Not hearing a response. I'm going to look at the participant list on the Zoom call. There's nobody in the courtroom that's coming forward in response to my calling of the name Brandon Lovato. Okay, I'm looking at the participant list. I don't see a Brandon Lovato on the line currently. I show this is your motion, and you're going by Ms. Hastings now, correct?
Yes.
Okay, this is Ms. Hastings' motion related to reinstatement of child support. I show that you served Mr. Lovato with all the documents on the 28th of February, where both parties had previously agreed to serve each other via email. And I'm not seeing a response from Mr. Lovato. So I'm in a position where I can sign off on the order that you submitted. And I believe you did submit an order, is that correct?
Yes.
Okay, let me just pull that up here. I'm just reading over the proposed order, Ms. Hastings, so just one moment, please.
Okay.
So one thing I wanted to touch base with you, Ms. Hastings, in your motion is to reinstate the child support, and then in your proposed order, you also added a provision related to claiming tax exemptions. And I wanted to ask if you raised the tax exemption issue in your motion.
So I believe I did. And since they're going to be living with me, and when we first did court with the GAL and everything, he said in court that he was moving back to Kelso, Longview area, so we can do like 50-50, like what we started out doing. But now he's saying that he is staying in Alabama. He's not moving back. So at that point, and then I was going to work with him and not even go down the lines of even asking for child support, because he said that he wanted to do something with his truck or something. And he said that he would just send me it directly so I wouldn't have to go through courts. But since then, he has been cussing me out, saying that he's not giving me a dime. So I think it's just appropriate just to get stuff signed in court. So I don't have to even go through him to ask for anything.
Okay. So in your initial pleading related to your motion, this is your motion that was filed on February 2nd, 2024 to reinstate child support. You're asking that the child support to be started, that Brandon gives me the girl's SSI and pays child support. And then your statement of facts is the cost of living, cost of clothes, cost of food. And nowhere in there do you raise the issue of tax exemptions. So that's why I posed the question.
Okay. Okay,
So-
I must have left that. I must have left it out on accident then.
Okay. So I'm not in a position to include that in the order. Since there's no response from Mr. Lovato, there was nothing that he filed in response to your motion. I'll grant the relief you're asking, which is the reinstatement of the March 30th, 2023 child support order, which requires him to pay $420 per month of child support, and that the tax exemptions therein in that order says that you claim Courtney every year, and you can claim Kaylee and Bailey in even years, and he can claim Kaylee and Bailey in odd tax years. So that's the order as it stands as of March 30th. So that's going to be reinstated. If you want to make any changes related to the tax exemptions, you'd have to file a separate motion, give notice to Mr. Lovato.
Okay, and then so I think in the original when we first went to court for because we were doing 50-50 at that time, and I had basically our oldest daughter full time because she refused to go to his house. So I think that's when I think it was you that ruled the $400 a month just based on my oldest daughter being with me full time, and then since he had 50-50 with the younger two, that he wouldn't have to pay me anything for them too, just our oldest daughter. How would I go about the, like getting that like reevaluated, since now I have all three girls full time and he only gets them I think it's like 8 weeks a year.
Right. Yeah, anytime that a party wants to change or modify an order, there needs to be a motion filed with notice to the other side given, and then set up for a hearing date and allow everybody to express their views, and then the court can make a decision based on those views.
Okay, I will. So is there like a time period, like after, since if this gets approved today, is there like a time period that I have to wait and like to come back to court to like have that reevaluated?
So as a judge, I'm not in a position to give legal advice, and what you're asking is legal advice, but I can give you some resources. You can check on a website. It's called WashingtonLawHelp.org, WashingtonLawHelp.org. There's lots of good materials on there that give a pretty detailed explanation on the like. And then also you can check with what's called the Clear Hotline. It's a hotline staffed by licensed attorneys in Washington that if you meet certain income requirements, they can advise you on legal matters.
Okay, I will look into that.
Okay. All right. So I'll get an order out that reinstates the March 30th, 2023 order, and that'll be reinstated effective today.
Okay, and then I guess my only other question is the last time we did like financials and stuff and submitted those, on his end, he now works, he gets SSI plus he works under the table. How do I go about proving that? Because I have like text messages and stuff like that, and like proving that he does like work under the table, and he makes quite a bit of money doing that.
So again, that type of, your request is a request for legal advice, which I'm prohibited from giving.
Oh, okay.
So you'd have to check some of those resources and or one of those two resources that I offered, or check with an attorney.
Okay, no problem.
Okay, so I'll get that order prepared and it'll be filed before end of business on Friday. Ms.
Okay, thank you. Appreciate it.
Okay, thanks. Feel free to take a seat, and thanks for positioning yourself in front of the microphone. I'll ask if David Rose is on the line. David Rose?
Present, Your Honor.
Okay, welcome to you both. Okay, we're on for a final dissolution matter, and there was a joinder. So Ms. Rose filed the petition, and then there was a joinder, what we call a joinder, signed by Mr. Rose, that he basically agreed with the relief that was being requested, but we wanted to have notice of any future hearings. And so got notice, he's here. So the petition, the one question I had is that, it looks like everything's in order. There's one difference between the petition and the proposed order. So normally when somebody signs off on a joinder, they say, hey, whatever the petition says, I'm fine with that. Just give me notice and we're good to go. However, here there's been a change from the petition to the proposed order. And that change is that the petition listed 8 credit cards to be divided between the two of you. And then the proposed order lists zero debt, that there's no mention of any division of any debt. So that's my only concern that I have. So I'll hear
So,
from Ms. Rose.
Your Honor, what I filed originally, I thought, was I listed my credit cards as my debt, and then he has one credit card that is his debt.
Okay.
All of our debts have already been divided. We've kept everything separate throughout our marriage. The only issue is the house.
Okay. And I certainly may have overlooked that or misread that. So let me just pull up the petition again. And then we'll give Mr. Rose an opportunity to chime in also. Right. Yeah, it does list the different credit cards. The vast majority are assigned to you, and with one going to Mr. Rose. And then in the proposed order, let me just pull that up here. So it looks like, Ms. Rose, you're in the proposed order, it basically says everything that's in your name, a debt that's in your name, you're responsible for it. And anything that's in Mr. Rose's name, a debt, he's responsible for those.
Correct, Your Honor.
Okay. All right. I think I better follow you. I follow you, understand you better, what you said before. So let me ask Mr. Rose, do you have any questions with either the issue that I raised or with the signing off of the findings and conclusions and the divorce decree?
There was a difference between the house. Sorry, excuse me. The initial paperwork sheet. Oh, I can't talk. I'm sorry.
You're okay.
Oh, Lord.
Yeah, take your time.
Yeah. It said the house would be divided up 50-50. I agree with that wholeheartedly. But the second one she initially said the house is in foreclosure, and the house isn't in foreclosure right now. It's a VA loan. It's in my name, and I don't want to lose my certificate to buy to their house maybe later on in life. We need to sell the house. I can't do it myself because we're both on the loan. I don't know what we're going to do about that. Thank you.
Okay. So on the petition, because kind of so here Ms. Rose proposed and said that neither can afford or qualify for an individual loan. So the house is to be sold and the equity split 50-50. So is that still the case?
Yes, it is. I was under the impression that the house was in the process of foreclosure because no payment has been made since October.
Okay.
His brother is a real estate agent. He contacted me and explained to me that he looked into it and it is not actually in foreclosure currently.
Okay.
So I was not aware that he signed the joinder until I filed the documents for the final order. I wasn't served with anything, so I wasn't aware of that. So I'm perfectly okay with a final order reflecting that the house is sold and to be split 50-50.
Okay. So on the proposed order, if we just strike the language that's there currently, which says the house at 320 on 25th Avenue, Longview is in the process of foreclosure and no judgment is needed, that would be crossed off.
Yes, sure.
And then just replace that with the house to be sold and equity split 50-50.
Correct, Your Honor.
Are you comfortable with that, Ms. Rose?
Yes.
Mr. Rose, are you comfortable with that change?
Yes, Your Honor. That sounds great.
Okay, let me get my whiteout and do that right now, and then I'll just share with you what the actual language says once I've finished making that revision. So there's a place for me to include the address of the home, and it's at the 3. And was it purchased during the duration of the
Yes, Your Honor.
Marriage?
Yes.
Okay. I'm proposing to say parties cooperate in the sale and execution of documents related to the sale of the home and proceeds to be split equity or split 50-50.
Agreed, Your Honor.
Okay. Mr. Rose?
Agreed.
Okay. Okay. So I wrote, party shall cooperate in selling the home. All proceeds shall be split 50-50. Ms. Rose, any concerns with that?
No, I agree with that, Your Honor.
Mr. Rose, any concerns with that?
No concerns, Your Honor.
Okay. All right. Also on the final divorce decree under paragraph 2, where it says summary of real property judgment, land or home, it was previously marked no real property judgment is ordered. I'm crossing that out. And then it says summarize any real property judgment from section 7. And section 7 is where I wrote in the home shall be sold with sale proceeds split 50-50.
Thank you.
So I checked that box that says summarize any real property judgment from section 7. Mr. Rose, any questions on your end at this point?
Negative, Your Honor.
All right. Ms. Rose, any questions?
No, Your Honor.
Okay. I'm in the process of signing both of those orders. And I'll note, Ms. Rose, you signed as the person that prepared the document. And I'm just going to put here on the respondent, Mr. Rose's, I'll just put present via Zoom. Okay, so I signed off both those orders. If the parties need copies of those, you can check with the court clerk in a couple days and get copies of those. So at this point, I don't have any further questions or issues. Ms. Rose, any further issues?
I do not, thank you.
Okay, Mr. Rose, any further issues?
Negative.
All right, that'll conclude the hearing today. Parties are present. Thank you.
Thank you.
All right, come on up and both perfectly positioned in front of the microphones. Appreciate that. Okay, so it looks like, so you're Mr., is it Norgren?
Yeah.
Okay, and you're Miss Sawyer.
Yes.
Okay. All right, so this is related to a temporary restraining order that was issued on April 8th, 2024, in which Mr. Norgren was restrained based on concerns of the sleeping conditions for the child Lila, and also concerns related to threats and drug use. And so that was the basis of what they call an ex parte, or where one side gets to share their view. And then we're here today related to whether that temporary order continues for up to a period of a year. So that's the purpose of today's hearing. So I reviewed the pleadings that the parties had submitted. I read over what Ms. Sawyer had submitted, and I read what you had submitted, Mr. Norgren, related to concerns related to Ms. Sawyer's DUI, or the stipulated continuance, and the evaluation. Okay, so I'll hear from the parties. I'll hear from you first, Ms. Sawyer.
So originally I had started the temporary order because CPS opened an investigation on him.
Mm-hmm. Do you know the status of that investigation?
They are closing it because they didn't find anything.
Okay.
So my intention for today was to come into court and drop the restraining order. Yesterday I did get a call from Deputy DeLapp with the Longview Police.
Mm-hmm.
He wanted to do a forensic investigation where he talks to my daughter to see kind of she will open up and tell him anything. And he would like that to be extended for 2 weeks out.
Did you submit a report to the police? Is that why he's taking action?
No, there was a time where I had taken my daughter to the ER for a really bad UTI.
A really bad what? UTI?
UTI, because her father did take her off of his insurance. So the hospital asked some questions, asked about the CPS case, and then had reached out to the sheriffs themselves.
When was the hospital visit?
I can't remember the exact date. It was sometime last month. It's on my papers at home.
So in March sometime? Okay. Okay. So with that information, you kind of shared two different things with me. One was your intent to come in and request that the restraining order be dropped, and then you shared that Officer DeLapp was requesting that it be continued for a period of 2 weeks.
Yes.
So what's your position?
I'm gonna go with him and go with the 2 weeks extended until it's closed and he's done with what he needs to do. If there's no findings there, then I would be more than happy to drop it.
Okay, thank you. Mr. Norgren, what's your position on all this?
I didn't know about the police officer wanting to extend it or any of that, or the investigation prior or after the CPS. The only thing I knew of was CPS investigation. They told me the same things, that they were going to be closing it. And aside from that, I didn't find anything out about anything else until my CPS caseworker called me yesterday and informed me of it.
Of the unfounded finding?
Yeah, about the continuing investigation they were going to be doing today.
Okay, so you learned about that yesterday from the CPS worker. Okay, and so what's your position related to the order, the restraining order, whether it ends today, whether it continues for a period of 2 weeks?
I mean, I would prefer it to end today to where I have visitation of my child, but I guess on the terms of if they want to continue the investigations, I guess that would be okay until that's finalized.
Okay. So we're looking. May 8th would be 2 weeks. May 8th would be 2 weeks.
Okay.
So is that what you want to do?
I'd prefer to have it dropped where I can see my kid.
Okay. Okay. Okay, so in preparation for today's hearing, I've read everything that was filed, and this is just new information that you both shared with me regarding to Officer DeLapp and also the CPS. That's new information. Sounds like you're both aware of both those bits of information, so you shared that with me now. Coming into the hearing today, my plan was to drop or end the restraining order today, and that was based on the declarations that have been filed. It just didn't seem like it was necessary to continue at this time. With the new information where it sounds like the hospital, there was a mandatory reporter there. Then they made a report to CPS, and that was sometime March, not sure how long ago, and that the officer wants to review things. It's called a CJAC interview. I think that's what they call it. Forget what the acronym stands for. Because right now, as far as the there's not a parenting plan in place currently, correct?
No, we're going to mediation next Thursday.
Okay, so you're going to mediation. All right. And then prior to the temporary restraining order, what was kind of your rotation or residential time with the
Every other weekend.
You had every other weekend in your primary?
Yes.
Okay. I think in abundance of caution and recognizing 2 weeks is in the long span of or long scheme of things, I won't call it inconsequential, but it's maybe what I'll call a small price to pay to make sure everything's okay. So I'm going to continue the order for 2 weeks. So we'll be back here on May 8th to review that, and any updated information from the CJAC interview would be key for that hearing. Because if there is something that's happening, then we'll know about that. Otherwise, we can take a look at things with that fresh information. So any questions on where we're at this time? So the order would be continued for a period of 2 weeks until May 8th. We'll meet again here, and then we'll get an update from what the police find or don't find, and then we'll go from there. Any concerns with that?
No, Your Honor.
The only one I had is, so until that's done, then it's still no visitation of my daughter then, correct?
That's yes.
Okay.
Yes.
Okay.
Okay.
Other than that, that's it.
Okay. Let me just do a quick notation to myself. So when I issue this order, the extension. All right. Thank you both for being here. We'll see you on May 8th.
Thank you.
All right. Thanks. Let me just change that. All right. So you're present, and then you're Kenneth Johnson.
Yes.
Okay. Very good. All right. I'll double check to see if Jennifer Schaefer's on the line.
I'm here, Your Honor.
Okay, there you are. All right, very good. Confirming with the parties, Ms. Schaefer issued her report. Ms. Johnson, did you get a copy of it?
Yes, sir.
Okay, Mr. Johnson?
Yes.
Okay. All right, and then Ms. Schaefer made several recommendations based on her report, such as anger management and evaluation treatment for both parties is recommended. One-on-one therapy is recommended for both parties. Taking a class for about co-parenting recommended for both parents. Reunification counseling, ensuring that the child's emotionally up to unsupervised visits, and then professionally supervised visits thereafter once that's been established. And then the use of Our Family Wizard, the app, or a co-parenting app. And for use in it's Ridian, right?
Yes.
Ridian. It's a cool name. I like that name a lot. And that would occur on Wednesday and Thursday, and then Ridian would have the choice to either answer or not answer. And then no disparagement of the other party, basically in any medium or form or means. So so that's the recommendation from Ms. Schaefer, and I'll just ask Ms. Schaefer, do you have any additional comments, and then we'll hear from both parties.
Not at this time, Your Honor.
Okay, thank you, Ms. Schaefer. Ms. Johnson, do you have any comments or concerns related to those recommendations?
I am happy. I think the reunification therapy would be good. I think Ridian in therapy would be good.
Mm-hmm.
I don't know about having to be professionally supervised. Ridian himself says, I don't yell at him. I've never hit him. I don't cuss at him.
Like, our relationship has always been fine. The issue was our marriage. And so me and Kenny had conflict, but there was never conflict between me and Riddy. But it has been a very long time. I haven't talked to him since June of last year. There's been no contact. There's been no checking of messages on Family Wizard. There's been no answering of phone calls. And so it's been 10 months of just me being out of his life. So I do realize it's gonna, it's difficult for him.
And Ridian's 8?
He just turned 9.
9, no, okay.
Last week.
Okay.
I do have concerns that Kenny, leading up to our altercation, had been secretly recording me. By his admission, there's 30 of them. He played them for Miss Schaefer, even though they were taken illegally. And he did get immunity for one of them, but the other 29, he does not have immunity for. And he's playing them to the kids. He's playing them to my daughter. He played them to the court investigator. I have concerns with him.
All right. Thank you. Mr. Johnson, do you have any comments related to the recommendations of the court investigator?
No, I think it's fair.
Okay. All right. Okay, so I'm not hearing any strong disagreement from either party related to those recommendations. The recommendations seem sound. Anger management, evaluation, treatment for both seems reasonable. One-on-one therapy.
Today at 3 for that.
Pardon?
I have an appointment today at 3 for that.
Okay, excellent. One-on-one therapy for both parents sounds like a good idea. I think most all adults should be engaged in therapy. It'd be helpful for all of us. The class seems reasonable. The reunification counseling there, it sounds like Ms. Schaefer recommended just that a counselor would check in with Ridian just to check emotional vitality or strength or resilience. And if Ridian's up for that, then that process would be guided by the counselor and would guide that reunification efforts. If the counselor is of an opinion that Ridian's not quite ready yet, then that would have to hold off for a bit. And it would have to be checked in periodically to see where Ridian stands with that. And then once he gets to a point where he's okay and good with that, and the counselor feels that he's robust enough to do that emotionally, then that would start. And then Ms. Schaefer, would it then be sequentially that professional supervision visits could start thereafter? That's a recommendation, correct?
Your Honor, it was an interesting case because at the end I did have to change my report and my recommendations because I was instructed to not use those audio recordings that I did hear several from. And if I was able to mention those audio recordings, I do feel that my recommendations would have been different.
Okay, so you excluded those?
Yes, I did. I didn't take those into consideration when making these recommendations. So I think counseling should occur first before the supervised visits.
Okay, so it is a sequential recommendation. Okay. All right. Well, not hearing any real strong disagreement with the recommendations themselves. I'll adopt those and I'll put that into an order. And I think the last one, the last recommendation is one of the harder ones. That no disparagement of the other parent. I think that's really, really hard because there's really deep feelings that go around and frustrations. But I think you're both probably well enough aware that any disparagement of a child's other parent is really a direct attack against that child, and that's the way the child interprets it. So I just encourage the parties to do your very best to protect your child from any such attacks. So
I've never been the one to bring him into the fights.
all right. So I will issue that ruling adopting the family court investigators.
May I ask a question?
Yes, go ahead.
So he was ordered to do reunification back in December and through the restraining order, and he dragged his feet till now, and he's not taking him to get it done. So what is like a time limit on this? Because he'll just not do it.
That is false, actually.
It's not false because it's lost happened.
So related to reunification counseling, so I'm adopting it at this point. So there's the child is to be taken to a reunification counselor, and that's to be assessed. And if the counselor feels that that's to occur, it's kind of a reasonableness standard. Within a week or so, an appointment should be scheduled. How far out that is, I'm not sure how long that takes or what their schedule is, but at least contact is made with the scheduling and get that scheduled within a week. So that'll be my order related to that.
If I could talk on that to clarify.
Sure.
There's only one person that does it in this county.
Pretty limited.
So it took me, yes, leading up into December, the end of December, which is Christmas, then January, New Year's Eve. I had to go through many organizations to find the one person here. And she stated to get reunification, because it's a two-party thing, it's $1,500 retainer fee for each person and $150 for a session. I put in a motion on my DVPO that the respondent be paid for her side, I'll pay for Ridian's side. And then they filed for contempt saying I'm just dragging my feet, not wanting to pay or doing anything. I have done many steps to find that one person with due diligence, and that was the timeline. Was I finally found her in February.
But it wasn't until April that he filed for.
Okay, so this issue, it's kind of moot at this point, because the order is going to say that the court's adopting the recommendations from the family court investigator, and that Mr. Johnson needs to schedule that appointment, if not already done so, within 1 week of today's order.
Thank you. Thank you.
And can you put in there if it's a dual counseling session that she wants, that she would have to pay her end, and then I would pay Radiant's.
And did you say that the restraining order addressed costs?
And they volunteered to pay for it.
Hold on.
Sorry.
So I was looking at Tim and asked the question to him. Go ahead.
So when we first did the DVPO, yes, I said I'll pay for it because I thought my benefits would cover it. I thought it'd be a financially obtainable objective, just to do things. But come to find out, if it's $3,000 I have to come up with, that's a financial burden I cannot do. That's why I put in a motion to modify my DVPO to have her pay, and I will pay Radiant stuff.
Has that motion been scheduled and heard?
I think it was carried over for this.
No, it was scheduled and heard. And they're not gonna address it because they took Ridian off of that protection order. Ridian now falls under the family court ruling. So you're the one
still on it.
So where's the what's the protection order number? Schaefer, do you have that handy, or any party have that handy?
It is 2-3.
April 22nd, court grants motion for modification and signs order. Court denies motion for contempt. Order modifying protection order. It looks like it was signed on the 22nd. Still, the actual order itself hasn't hit the Odyssey yet, so I can't see it. But I can pull up, let me take a look at the notes.
Yeah, she just changed a couple of paragraphs where Ridian would be, family court basically is supposed to decide what happens.
So I'll go ahead and just read the notes, and then if I need clarification, I'll ask. Says all contact between minor child and respondent will be addressed in the family law matter that will also include the cost of the reunification counseling. So she said, I'm not making a decision on that. This court will make that decision, correct? Right? Okay. Right. Mr. Johnson, what's your monthly income?
4,000 gross.
Net
is after taxes. I'm sorry.
Correct.
Okay. It is like 3,800, maybe 4,000.
Okay. Ms. Johnson, what's your monthly income?
About 2,000.
Okay. And the total, the retainer is $3,000. Is that what you're saying? Or is
for
it
both parties? Correct. It's $1,500
each party. Okay, and then thereafter it's $150.
Correct.
An hour. And there's no insurance benefits available?
No.
Okay.
Kaiser doesn't cover it.
Yeah. Bear with me one moment. I'll hear from you both what your positions are as far as the splitting of that cost. Ms. Johnson?
I'll split it.
Okay, that makes it easy. 1,500 each. Okay, I'll include that in the order. And I'll put as far as ongoing reunification costs, the hourly, what's your position on that?
I'm kind of confused by that because if she's taking $1,500 for each of us, isn't that like 10 sessions right there?
Sure. I mean, that's what the retainer does. They bill against the retainer, and then if they expend all of that retainer, then they would bill.
Okay, then I would do my 150. Like I would cover mine. I'm fine with that.
Okay. So 50-50.
Yeah.
Okay, Mr. Johnson. Yeah. Okay. All right. All right. I'll include that in the order as far as the cost of reunification and counseling.
Okay.
Any other items that need to be addressed?
No.
Okay. I'll get that order out and I'll get it filed before the end of business on Friday, and the parties can look it up or get a copy in a couple days.
Awesome. Thank you so much.
Great, thank you. Looks like the parties are
Thank you.
present. All right, so you're Mr. Robert Warmdahl?
Yes.
Okay.
Correct.
All right, welcome. And you're Ms. Alexis, is it Mierendorf?
Yes.
Mierendorf, okay. Welcome to you. All right. And this is related to Mr. Warmdahl's motion for a restraining order. There's a temporary order that was issued, and then we're here to make a determination if that continues. And then this is also Mr. Warmdahl's motion for a temporary parenting plan, correct?
Correct.
Is that your understanding, Ms. Mierendorf?
Correct.
Okay. All right. So let me just touch base with the parties a little bit, because when I looked at everything that I know about the case comes from the written word, right? So you submit declarations, you submit proposed orders and the like, and from that, I glean your particular position. So what I know from this case is that there's been a financial declaration filed by Ms. Mierendorf, and she also filed a proposed parenting plan of what you feel is in the best interest of the child. And then you also filed a response to the petition, which is basically where you agree or disagree, that little sheet that you go down. And then it's, a few statements. We've never been to court for child support. I'm not a danger to my child. So there's that information. And then I read the motion filed by Mr. Warmdahl related to the emergency or the immediate restraining order, where it simply states allegations of severe abuse in mother's home. CPS is involved. There's a hospitalization due to alleged abuse. And then it asked for approval of a parenting plan to protect son's safety from possible abuse. And then there's a motion that says CPS involvement due to allegations of child abuse in mother's home. And then a final financial declaration of Mr. Warmdahl, a paternity document establishing paternity that you're the parents, a proposed parenting plan submitted by Mr. Warmdahl, lays out his position. So what I have is basically stuff that you want, each of you want. But what I don't have is like explaining all the details of how you get to your conclusions. So that's where these declarations are really important, where you write out declarations either from yourself or individuals who have knowledge about the case, and they submit declarations to the court for review to give me some meat on the bones, or meat on the skeleton, if you will. Because right now I've got the skeleton. I know what you want, but I don't know how you got there. So I for myself, it's very difficult. It sounds like, there's some big concerns on both sides, but I know very little of it, and and I don't expect you to do this perfectly. You don't come to court regularly, and so what I need from you all are declarations, explanations of how you get to the conclusions that each of you want me to arrive at. And so there's a couple different resources you can look at. If you go to the Calais County Superior Court website and you look under rules, you can look under Rule 88, Local Rule 88. That'll tell you the number of declarations you can submit, either by yourself or supporters, the length, how many pages, and then you can submit those to the court. So at this point, I don't know very much about what's going on. So I need you to tell me what's going on. And the way you tell me what's going on is write it down, submit it to the court, submit the declaration, what you wrote down, give a copy to the other side so they know what you're saying. So that's a long way for me to say that I don't have enough information to make a decision, and that any temporary restraining order, it would continue for a period of time until I have those declarations and have that information in my hands to make a decision. So that's kind of where my position is at this point. So Ms. Mierendorf, you're the restrained party. So I just want to hear from you if you have any questions about kind of the court's position or any concerns.
I would like the restraining order to be removed just because I wasn't trying to use something horrific that happened to me against me. I wasn't home when it happened. I was not involved. And the restraining order doesn't really make sense because it doesn't really mention me or stating why in there. It just mentions more of my ex-boyfriend that committed the crime.
Okay. Yeah, and that's information. You've got a lot of information there to share with me that I really don't know anything about. So yeah, there's lots more that I understand you want it to be dropped. That makes a lot of sense. And I understand that you've got a lot of information that I don't have. Mr. Warmdale, do you have any questions or concerns?
So I gotta look up Rule 88 or
Local Rule 88.
Local Rule 88 and then put in declarations.
Yeah, declaration is basically, it's a statement by yourself or others who have knowledge about the case of what's telling me what's going on and why the relief that you're asking for is appropriate. And then you'd serve a copy, you'd file it with the court, you'd give a copy to Ms. Meindorf. Yeah. And then she'd have opportunity to respond to your submissions.
I can try to do that as soon as possible. So like, is this right here just going to get pushed back or?
Yep. Until I have more information from you all of what's happening or not happening.
Okay.
So we're looking at May 8th is really full. I think I moved a couple of cases to that. We're at 18. And we're at 18, 17, 18 today. And the restraining order has been in place since March 20th, I understand. So I think I need to continue. Yeah, we need to continue it. We're not available on the 1st because of that judicial conference that I mentioned before. We're at capacity on the 8th, and the 15th would be the next available period. So that's what I'm proposing that it be continued to May 15th at 9 a.m. I'll ask Mr. Warmdall, are you available on that date?
May 15th? Yes.
Okay. Ms. Meindorf, are you available on May 15th?
Yes.
That's a Wednesday at 9. Do you have any questions or comments?
No.
Mr. Warmdall, do you have any questions or comments?
No, sir.
Okay. Get that information to me in the form of declarations, submit it to the court clerk, and then make sure you send a copy to the other party.
So is it just like a paper I write on, like with a statement on it about?
Yeah, it's a good question. It's a good question.
It's like a court.
There's another website you can go to. It's courts.wa.gov. And then just type in forms after that. Like you go into Google and you type courts.wa.gov and then type the word forms.
Yeah.
It'll pull that up and just look for dissolution or divorce. And then there'll be some forms there. And just do like a Control F and just type in declaration. And it'll pull up a Word form for you. And you could either type it right there or you can print it off and then handwrite it however you'd like.
Okay.
Okay. Any other questions?
No, that was it.
Mr. Warmdall?
May 15th.
May 15th, 9 a.m. Okay, we'll see everybody then. Give you a moment to get settled. All right, and Mr. Knuth, do you pronounce your last name? Is it Knuth?
Correct.
Okay, all right. Mr. Knuth is present. Ms. Bender is present.
Yes.
We're on today this is a motion brought by Mr. Knuth for a temporary parenting plan. Looks like the records show that Mr. Knuth has served those documents upon you, Ms. Bender, on or about March 28th. Did you receive a copy of his motion?
Yes.
Okay. All right. And then I reviewed your submissions, Mr. Knuth, and I also reviewed your submissions, Ms. Bender. Just kind of in summary, there's concerns related to Mr. Knuth raises concerns related to not seeing the two boys for roughly several years. He's concerned. He raises issues of SUD, neglect, withholding, and raises issues of SUD or alcohol or drug issues. You indicated that you've been in IOP since July of last year, that you're in a clean and sober living, that you're working part-time, and then it sounds like you have another child, Iris?
Yes.
Okay, and that's not Mr. Knuth's child?
No.
That's okay. And then you're concerned about domestic violence, assault, and SUD evaluations, and the like. So I think that's kind of just in general kind of the feel of some of the issues that the parties raised. Obviously, there's much more. So I'll hear from you, Mr. Knuth. This is your motion for temporary parenting plan. So.
Okay. Kimberly and her sister have taken the boys while they were on the run and failed to inform us, as me and my wife have been raising the boys for the past several years, I was a single parent before we got married, and we've been married. This summer will be 5 years we've been married. And the boys have lived with me the entire time. And failure to inform me when you pick up the children and take them to a neighboring county, I feel is not acting in an appropriate manner of a parent concerned for the child. And
when did that happen?
Approximately
January of this year.
Yes.
Okay. And have the boys remained with Ms. Bender since that time?
I don't know. They have not. Gunnar has not been home in a while, and Odin was home for a while, and then Kimberly was driving him around without a license, specifically his court over at the juvenile building. And I currently have Division of Child Support and Longview School District both breathing down my neck over Gunnar because Kimberly's sister, Erin, who has custody of our oldest child, Haley, is trying to get child support for Gunnar when, if Kimberly is not going to be the one raising Gunnar, I was under the impression state law required you prove me unfit in order to have a third party raise my child.
So right now, Ms. Bender's sister has custody, or that's where Gunnar's living right now?
As far as the Division of Child Support has informed me.
What's your understanding? Where is Gunnar living?
Not where he should be.
And where is that?
I believe that he should be residing with me and my wife.
Okay. Is Odin living with you? Where's Odin?
The last time I seen Odin, he was with Kimberly while she was driving without a driver's license to take him to a court for some of the shenanigans he pulled while on the run.
Okay, so the best of your knowledge, Gunnar is living with his aunt.
Correct.
And Odin is living with Ms. Bender.
Correct.
Okay. All right. And so your request in your parenting plan is that you be named custodial parent and that Ms. Bender have second and fourth weekends supervised to clean you away 24 hours before and valid driver's license.
Correct.
Tell me some of your thinking why that's your request. Give me a little more detail of what you're asking.
She has not been able to consistently call the boys around like holidays. I mean, if you have issues and things you need to work on, I made a request that she try and call the boys once a month and just spend a few minutes on the phone with them so that we can avoid things like reconciliation that you were discussing with a prior case. If you call and have a conversation and prove to me that you can be consistent with that, I'll skip the courts and let you have visitation. My family's into kayaking and fishing. Meet us at the lake and spend an afternoon with your children. And that was not something she was willing to do. And she wasn't willing to call consistently and have conversation to prove that she has corrected the issues that she is claiming that she has been taking care of.
So your position is that prior to January 2024, there was no contact between Ms. Bender and the boys?
Correct.
Okay. And then did you see, what's your position related to Ms. Bender? Ms. Bender submitted information related to being an IOP and clean and sober housing. What's your position related to that?
Once I managed to get her served, which I asked for an address to serve her at when she took Gunnar to his juvenile court, she refused. And I managed to get a mutual acquaintance of ours to serve her, and I never got served anything back that she was responding to the court.
Okay, so you haven't seen the response of Ms. Bender?
Correct.
Okay. Could I just address that briefly with you, Ms. Bender?
Yeah.
You submitted some information related to your position, where you're at in life. Did you send a copy of that document to Mr.
No, I did not. I was supposed to. I'm new to this parenting
Okay.
plan stuff.
Okay. Well, I'm glad we addressed that point. So what happens is that Mr. Knuth submitted some documentation, his motion, submits to the court. I read it, and he sends a copy to you. You read it. And so then you have an opportunity then to respond to the court, which you did. You sent it to me, and I read it. And then he needs to have Mr. Knuth needs to have an opportunity to read what you're saying. So that way you get to read what he says, and he gets to read what you say. And then we come here, and then everybody's informed. So we're kind of a little bit short-circuited here today because we know what Mr. Knuth is saying. I know what you're saying. Mr. Knuth doesn't know what you're saying. And so that would be important for us to know before we move forward. So right now, can you tell me what's your position as far as where Gunnar is living?
Gunnar and Odin are both staying with me. They go to my sister's during the day while I work, and they are enrolled in school. Gunnar and Odin are both doing excellent. They're not running away. They're not getting in trouble with the law.
Okay.
I did go a period of time without talking to them, but I was on drugs. I've been clean and sober for almost a year, as a matter of fact. Like I submitted, my CPS case with my daughter is reunification this summer. I'm an outpatient. I'm in clean and sober housing. I'm working part-time. I have 2 drug and alcohol mentors. I'm in parenting classes. And I did drive Odin to court because I had no other transportation, but I do have transportation for future.
And you're residing in the Portland area?
Yes.
Okay. And are the boys enrolled in school there?
No, they're enrolled in Vancouver.
Okay. And they're doing online school?
No, they're doing in class.
Okay. Okay. All right. So this kind of highlights that the concern that I have is that you're sharing this information and Mr. Knuth is hearing this for the first time, right? And so he needs to be served with a copy of the documents that you submitted. And then he has an opportunity to digest that, and then we can move forward. So there's a couple ways we can approach this. One is maybe one option is to make a decision today kind of on imperfect information. All parties haven't received all the information and digested it. That's one option, is to move forward today and make a decision. Another option is to continue the matter for a period of time, allow you time to serve Mr. Knuth with your documents. And if he wanted to send a reply, he could submit a reply and to the court and to you. And that would occur at a later time. So those are our 2 options. So Mr. Knuth, this is your motion. You did serve timely. So we could move forward today with kind of the situation we're in, or we could set it over a period of time and allow you to receive and read what Ms. Vedder is saying.
I have 2 things that I would like to say, but we got distracted with me not getting served. Number 1, as of last week, the boys were both still enrolled in LVA as I went down to try and tell when the school district of Longview tried to come after me for truancy. I gave them the case number for the detective I'm trying to get custodial interference charges on and told them, I cannot do anything unless you can make this detective return the boys to my possession.
Is there a current parenting plan in place?
So, long story, try and make it short. In 2013, I got sentenced to 18 months in prison. Kimberly signed custody of the boys over to some relatives, and I went with my mother, who was in the courtroom. She got custody of the boys from the relative that she had signed custody over to. And then once I proved, I believe it was 6 months of holding the job I had in work release and living with the boys, then she signed custody of the boys over to me while Kimberly was not in the picture. I currently have the Division of Child Support for Washington State telling me that Erin, Kimberly's sister, is claiming TANF, so they would like to go after me for child support on Gunnar. Both boys are currently enrolled in Longview. As of last week, we're currently enrolled in Longview School District. So I really question how they were able to get them enrolled in Vancouver School District without unenrolling them. And with the sister having custody of them according to the Division of Child Support, that's not legal, as you have failed to prove me unfit.
So there's no parenting plan in place?
There is no parenting plan in place. I was under the impression that me getting custody returned to me after I got out of prison, while Kimberly was not in a position to attend court or be an active part of the children's lives, was all I needed. I didn't understand until dealing with this situation that we had to get a parenting plan. I thought a custody order was good enough.
Okay, so it's just kind of the historical pattern is what you're relying upon.
Yes.
Okay. So, so then I guess going back to my initial question related to the two options moving forward today with kind of imperfect, short-circuited process, or setting it over, giving you opportunity to have Ms. Bender serve you with the documents.
I would like to get this handled in a timely fashion, as Miss Bender's sister, who she's claiming the boys reside with during the day, has not been a good influence on Gunner's older sister, who happens to have a drug problem that follows the path of her mother and her sister and her mother's sister.
So when you say timely resolution, kind of still begging that question of whether your position is to move forward today or set it over, it'd be 2 to 3 weeks.
I've already, because someone refused to give me an address where I can serve them, I've already been forced to set this out over a month, as the local police department here and Vancouver refused to be responsible for serving Kimberly, as she is notoriously hard to find.
Okay, so you want to proceed today?
Correct.
Okay. Ms. Bender, as far as your position, do you want to proceed today, or do you want to give the papers to Mr. Knuth and come back in 2 to 3 weeks?
It seems like he wants to proceed today.
That's his position.
My position is I can get proof from the schools saying that they are enrolled. I don't know what else he would want besides what I've already said and what I've already put in.
Okay.
What I've already submitted, I'm sorry.
Okay. I think that this is what I feel comfortable doing at this point. Historically, it sounded like Ms. Bender has struggled with drug addiction issues, and Mr. Knuth has been the one raising the boys after he was released from prison. And then now that Ms. Bender is doing better, she has the boys as roughly from January of this year. They're still in her custody. There's some dispute of whether they're still enrolled in Longview or they're enrolled in Vancouver. But the import of that is that they're living with mom or living with Aunt Erin, I guess. So we have kind of those competing interests of kind of a long-standing residential practice of the boys being with dad for roughly 3 years, mom doing better now and having the children with her, and the best interest of the children is squarely at issue at this point. So there's several issues that I don't have a lot of information on. As far as Mr. Knuth raises issues of neglect by Ms. Bender, withholding of the child, which is kind of interesting. I'm not quite sure how that fits, because of the withholding would say that I guess he's been withholding since January. That would be your position, and lack of emotional ties. I'll get to your question in a moment. And then Ms. Bender, your position is that you're doing better with your drug addiction. You're clean. You're still working through a child dependency with your younger daughter, and you want some evaluations done related to assault and DV. So there's a lot of things that remain kind of unaddressed and really not fully spelled out for me that I think I think I would benefit from having our family court investigator dig in a little bit to get a clearer picture of your position, get a clearer position of your viewpoint, and then come back in. It would be a fairly quick turnaround time, and I'll double check to see if Ms. Schaefer's on the line. She is.
I'm here, Your Honor.
Ms. Schaefer, do you have I'm contemplating appointing you to do a pretty rapid investigation. Obviously, it's not going to be extremely in depth. It's more kind of just to get basic parameters and get the points on the map, if you will. I'm not sure if a time frame of 3 weeks, and I recognize probably for Mr. Knuth that seems like forever. However, I'm just thinking 3 to 4 weeks, how that works with your time schedule and your workload, Ms. Schaefer. Probably May 22nd.
Would I need to have the report to the parties by the 15th for consideration, or?
Probably by the 17th, as long as they have it a few days before.
I can make that work.
Okay. I think I need that. I think that's important in this, where there's there's a lot of historical information. There's some new information related to schools and the well-being of the boys and the like. There's also the issue, and it sounds like, the boys are going over to juvenile. There's mention of like driving them without license and the like. So the boys, it sounds like there may be some involvement at the juvenile department. So that's what I'm going to do. I'm going to play the family law investigator. She will be reaching out to you via phone or email, and I just want to make sure that we've got good numbers for you. So, Mr. Knuth, I'll just verify with you, or Ms. Bender, I've got a phone number ending in 1094.
Yes,
And down in is it a Vancouver address? Okay,
Yes.
Is that a good address?
that's a mailing address, yes.
Okay, but the phone number is valid.
Yes,
She can contact you there.
Yeah.
And then Mr. Knuth, as far as you, I've got a phone number ending in 1365.
Correct.
And you're on 20. All right, so she'll be reaching out to you, and please respond promptly to her and to share and get back with her, and she'll set up interviews and talk with you, and then she'll get a report out prior to the hearing on the 22nd, and then we'll be back here to just determine, we'll hear the motion of the parenting plan. Mr. Knuth.
The boys have been residing with me for considerably more than 3 years. I believe my mom just pointed out that 11 years. It was 2015 when I had the boys living with me.
Okay.
So 9 years without having visitation rights with their mother.
Okay. Significant issues remain to be addressed, and so the family court investigator will dig into that and talk to you and others, and then we'll be back here on the 22nd to hear the motion that was brought by Mr. Knuth.
Is there any way to get stiffer sanctions put on people for committing child endangerment by operating a motor vehicle with a minor in it?
Anytime that there's concerns related to child safety, the options is that individuals can contact CPS if they feel there's an immediate danger to the child. If they feel that the law is being broken, a person can report that to law enforcement. So those are two options.
On the incident when Kimberly showed up at Odin's court date, I pointed it out to both Calais County Sheriff, Longview Police Department, and was told by CPS that it's not their concern. But the safety of my child needs to be someone's concern. And if it's not Child Protective Services, who Kimberly and her sister have sent after me the last time, 3 out of 4 allegations had already been investigated with unfounded, and the 4th one was deemed not to be illegal. And now I have the police department and the county sheriff telling me that protecting my children is not their priority. They're not willing to risk their badge to arrest somebody for operating a motor vehicle without a license with a minor in the vehicle.
So those are the two options that I'm aware of. So we'll be here on May 22nd to address the issues that the parties raised. So everybody, yes,
May 22nd at what time?
9 a.m.
Okay, thank you.
Okay, we'll see everybody then. Thank you.
I get that phone number
Of
for contacting Kimberly so that if I need to serve her with more documentation, I actually have a way to arrange it.
Yeah, the document, it's she listed it on her pleading. Ms. Bender, is it
Would that be on Boone's house? Okay. And your phone number?
All right, we'll be in recess. We'll see everybody on May 22nd. Thanks for your input and help.